This conference will now be recorded.
Thank you to Todd and Matt and Reeve for really taking a lot of time and effort and putting in a very high quality draft recommendation for us to consider, taking the feedback that we provided at the last meeting very seriously. So thank you for that. Before we go further, I just want to turn it over to Matt for some opening remarks, and then after that, Todd will call the roll.
Connor, why don't I just turn it back over to Todd and we can get going here. I won't consume people's time. I know there are some distractions for a lot of people this afternoon, so you might as well just go forward.
Thanks, Matt. Todd, I'll turn it to you.
Great. So Connor Rosso, the committee chair, is here. I'm calling the members of the Committee on Regulation now. So Paige Bullard.
Here.
Clay Cook. Christopher DeMuth. Jonathan Doles.
Here.
Alice Kottmeyer. Elliot Law. Erica Litson. Michael Livermore.
Here.
Danny Fischler, alternate for Christina McDonald. Sheila Novak, alternate for Carrie Ricci.
Here.
Jonathan Rose. Jay Schwartz. Sid Shapiro. Ganesh Chatarman. Peter Strauss.
Here.
Anjali Singh, alternate for Chin Yu.
Here.
All right, so those were all the committee members. I'm now going to call the names of people who are not on the committee. Jeff Lubbers.
Here.
This is Jonathan Weiner. Am I not on the committee?
You are on the committee, Jonathan. Thank you for, thank you for letting us know.
Alice Kottmeyer.
This is Sid Shapiro. I'm here. I got in a little late.
Okay, so Jonathan, Sid, anyone else from the Committee on Regulation who I have not called yet?
Hi, Todd. This is Danny. I think you called my name, but I wasn't on yet. Thank you.
Got it. Okay, anyone else? From the Committee on Regulation. Okay, so now people who are not on the Committee on Regulation. Jeff Lubbers.
Here.
Dan Cohen. Kate Sargent. Jillian Metzger.
Here.
Steph Tatham. Steph, are you here?
I'm here. Thanks.
Okay, great. Brady Tonsing. Levon Schlichter. Ryland Lee.
Here.
Jim Tozy.
Here.
Peter Constantine. William Funk.
Here.
Paul Noe.
Here.
Rob Carter. Tim Mullins. Maureen Ruskin.
Here.
Lisa Stewart. Peter Robbins. James Goodwin. Neil Eisner. Bridget Dooling. Radha Vishnu Vijala. Keith Holman. Daniel Flores. Don
Todd.
Elliott.
Todd, this is Keith.
Daniel, is that you?
No, this is Keith. I'm on.
Oh, hey, Keith. Great. Don Elliott. Jill Laptosky.
Here.
And that is it. Okay, great. Anyone whose name I haven't called?
Alice Kottmeyer.
Charlie Maresca. Chris Shelton.
Matthew Manelli.
All right. Connor, I think we're good to go.
Thank you very much, Todd. As we've done the previous two meetings, I just want to quickly go over our ground rules. And as we sort of said, these feel a little bit different than when we're mostly meeting in person. ACUS members have full speaking privileges and can unmute themselves. But please keep your microphone muted and either physically raise your hand or add a comment in the chat feature if you'd like to speak, and then I'll call on you and you can unmute yourself. Chat feature has been, I think, working pretty well the first two meetings for creating a queue. I'd also ask ACUS members, please use your webcam, and then we'll do our very best to see you if you raise your hand. Please note, we welcome participation of ACUS members, but ACUS members are given priority in speaking today. For members of the public, please use the chat feature if you'd like to speak, and I'll turn to you at the appropriate. And Jennifer, I think, can unmute you with the GoToMeeting software. And please just use the chat feature for procedural stuff like asking to be recognized to speak. Please don't add substantive discussions in the sidebar, as people will start getting drawn to that and away from the main discussion. We just want to keep focused with one discussion so things are not unwieldy. We will vote at least once today at the end. And so only committee members will have a vote, and we will try voting by show of hands. And Todd will help me count, but please don't vote unless you're a committee member. And if necessary, we'll use the chat function to vote if we're having a hard time with the hands. And I think that's it with the ground rules. As Matt said, I'm sure people have a lot going on today, so we'll launch right into it. Hopefully we won't need the full 3 hours. And with that, I'm going to launch in and just open up the first 3 paragraphs of the preamble. So I'm working, just to be very clear, I'm working off the red line that Todd sent around. The red line includes some written comments that we got, and we can discuss those as we get to them. So on the red line Todd sent around, I'm working off lines 1 through 21. So I'll open up the preamble lines 1 through 21 for comments. And I think some people are expressing concern about their audio. This happened to me last time. If you're having a hard time with your audio, Todd has put in the chat function the phone number and access code to call, and that should work. And Jennifer can help you. And I see Steph Tatham as a comment on the preamble.
Hi, this is Steph. Thanks so much for calling on me and for letting me attend, despite being a member of the Committee on Judicial Review. I just had a really minor comment, and I think it's in these first 3 paragraphs, but it was in the discussion of, I'm sorry, mine's in the recommendation. So it's on line 3 to 4 and in the recommendation as well. The language I was hoping we could have be the same in both places, but if we're just looking at the preamble in lines 3 to 4, it says coordinating with the White House and other agencies as the rule is being formulated. I would just substitute the White House with either OMB or OIRA, no strong preferences as to which, and then I think that's fine.
Todd, Reeve, in drafting that, did you mean to encompass some of the other White House agencies in the White House apparatus, or did you want to confine it to OMB and OIRA?
Connor, that would occur through OMB and OIRA, so they would coordinate with OIRA or OMB, then through OMB and OIRA they would coordinate with other agencies, but it's typically a facilitated process.
That change wasn't, Reeve, that language wasn't. The White House, that was just casual usage. It was not meant to mean anything. Steph is correct, isn't she?
Exactly. I would be, yeah, definitely in favor of changing it to probably OMB would make the most sense.
Yeah, 12866 uses Ohio Res, but ONB is fine too.
Any objections to a change along those lines, as well as conforming in the recommendation? Okay. And next, I think we've got Anjali.
Yes, hi, can you hear me?
Yes.
Okay, at paragraphs 20, or lines 20 to 21, it would be helpful just a clarifying edit. The Federal Register is broader than what's codified in the CFR, so it would be helpful if we talked about something being only in the Federal Register, not only in the Federal Register, but also in the Code of Federal Regulations, which are the permanent rules published in the Federal Register. Others may have had a similar thought. Sorry.
Todd, did you want to mark that up on the in the black line?
I'm just not sure I understand what so the sentence currently says they appear on agency websites and are often published not only in the Federal Register, but also in the version of the Federal Register called the CFR. So how did you want to change that?
Well, basically remove version of the Federal Register called the Code of Federal. So version of the Federal Register called that's the language that could be removed, because the Federal Register is broader, as we all know, than just what's published in the CFR, and it would be helpful to distinguish the two as separate items.
Mike, just quickly on this, maybe the portion of the Federal Register. Does that work for you?
I think that would also be reasonable. Other people may have different phrasing in mind as well.
One could also add the word daily before Federal Register and then just use CFR at the end.
Okay, as long as Federal Register doesn't necessarily appear twice unless we're qualifying it as a portion that's published in the CFR, should be fine.
What do folks think about, Todd, put it up there. Then maybe we put Code of Federal Regulations in long.
Fine here.
I had a comment on the same point, and I just thought that it's a little confusing to talk about the CFR as a version of the Federal Register. I mean, technically, it is, or people don't think of it that way, and so I would have just taken out the version of the Federal Register called as Anjali originally suggested.
How do we, Jeff, when we spell out CFR, are you happy with the language now in the Daily Federal Register, but also in the Code of Federal Regulations?
Yes.
Okay, that seems fine to me. Any objections to that version? Danny Fischler.
I know that we ought not do this for every paragraph. I just wanted to express some appreciation for the rewrite here in the first few paragraphs. I thought it was very faithful to the discussion that we had at the last meeting. So thank you to Todd and Connor for that.
Thanks all due to Todd Reeve and that. Prashant. Wanted to mention regulations.gov at line 20. I'm not sure I followed that. Peter Strauss, make the third word in line 20 in. Oh, publish. Okay, I think we have that now. Oh, not.
Meg, as long as you've called on me, may I ask why our pictures are being shut off? It really feels more like a meeting if we can see faces.
I think the pictures are smaller because Todd's sharing his screen.
That's
But I
fine.
see,
We can
I
still
see many pictures.
You don't see mine anymore.
Nope, yeah, so there's a there is occasional bandwidth reaching. So right now I'm going to shut off the videos of everyone who's not on the committee.
It may be an automatic software thing. I defer to Jennifer, Peter, but no one's trying to shut anybody off. Okay, additional comments on the preamble up to line 21. Okay, hearing none, I'm going to move then to the 4 objectives paragraph, which is lines 22 to 31. Lines 22 to 31. Hearing none, we'll go to the next paragraph. Actually, I'll open the rest of the preamble, lines 32 through 49, and I'll first turn to Don Elliott's proposed edit, since he submitted that in advance. Even actually before that, Todd, do you want to summarize the research you've done? I should have turned to you first on rules on rulemaking and disclaimers. I'll let you speak to that first, Todd, and then we'll go to Don Elliott's edit.
Yeah, so the disclaimer language that appears in the DOT rule, which says basically something to the effect of the rule is not judicially enforceable, it doesn't create any rights, substantive or procedural. We found that type of disclaimer in several other rules on rulemakings. I wouldn't say it's very widespread, but it's definitely not rare. So of the 27 rules on rulemakings that my research uncovered, 5 of them had this similar kind of language. So that was the post-committee research that I did on that question.
Thank you for that, Todd. And so, Don, I don't believe Don Elliott is on. Am I correct?
Yeah, I don't think he was able to join today.
But Don had made comments along these lines, suggesting an edit here. You can see what would be taken out with respect to courts and how they would consider these disclaimers that Todd had just researched. And so you can see his language. So I opened the floor to discussion on Don's language as opposed to what the committee had originally drafted. And I see the comments. Steph, take them on Don Elliott's point. And Steph, if you want to speak to how the ACUS treated this issue in the severability recommendation, that would be welcome as well.
Sure, I'd be happy to. We did discuss this issue in the Committee on Judicial Review when we were discussing how courts should treat agency severability provisions. And I think that committee spent a lot of time thinking about that question. And that committee is a very different composition from this committee. It includes a lot of private litigators. And there was some discomfort from individual members of the Committee on Judicial Review with the idea that we should tell courts to give deference to agency action. And so I think what the Committee on Judicial Review ended up doing in that particular circumstance instead was to say that agency should include in the statement of basis and purpose a clear explanation of the reasoning that they felt, it shouldn't be judicially reviewable or it should be severable in that particular case. So I had suggested doing something similar here. I don't have particular concerns with the direction that Don is proposing to go, but just did want to ventilate that issue and then take a more minor quibble with the idea of giving great deference, because I'm not sure what that means, and the amount of deference that a court might give might depend, given current case law, on the procedures that the agency undertook. And we've talked about how there might be different procedures here. So, just expressing a little bit of discomfort around that language, although I'm not sure exactly what I would replace it with.
And Steph, is the language that was used in the severability recommendation something along the lines of agencies should provide a reasoned explanation for the disclaimer, something along those lines, or for the severability clause in that context?
Yeah, I can pull it up. I have it right here. Agencies should likewise address their determination of severability in the text of the final rule and provide a reasoned explanation for that determination in the statement of basis and purpose.
Okay, so that's in the severability. So that, just to throw that precedent, Jeff Lubbers on this point.
Yes, I understand what we're trying to do here, but I think Don's language goes a little bit too far. There's a general principle in administrative law that agencies should follow their own procedural rules. And so if the agency did want to put this in the CFR as a, I think the statement is sort of contradicts that principle, that courts should give great deference to, to not enforcing a rule of procedure that's in the CFR. So I don't have a fix. I don't like the word great either, particularly. But I think the problem is really more about the type of rules that get put in the CFR. And if they are rules of procedure, courts are going to enforce them. At least some courts are.
Jeff, what was your view of the original language that's in the comment bubble? Maybe you can't see it on the screen now, but the original language is courts should consider such provisions in determining whether to hold rules on rulemaking enforceable.
I think that doesn't really give the courts much guidance. I guess I'm focusing more on the issue of whether it's in the CFR. Because if it's in the CFR, then courts are going to likely hold them enforceable. So maybe we need to address that issue.
I think our goal is to try to stay out of that to the extent possible and sort of bracket that for agencies. But I welcome comment, Danny Fischler.
But in that case, we're trying to direct this paragraph to the courts. The courts should give great deference. Why should we be telling the court something that maybe is contrary to administrative law principles?
That's why I prefer the original version that's doesn't get in specifically into this, but Danny Fischler.
So I like the specificity of Don Elliott's version, but I appreciate the concern that's been raised here. If we replace the words great deference with due consideration, would that help?
I would prefer that, but curious what other folks think.
Connor, can I just jump in here?
Please.
I think due consideration doesn't, I mean, it's fine. It doesn't say anything. I mean, it doesn't, it's sort of a truism. I mean, I think one possibility would be to take this, I don't have a strong opinion here, but one possibility would be to take this sentence out altogether. Courts are going to do what courts are going to do. And this recommendation is not likely to affect their decision-making on this point.
I know in previous contexts, we've expressed some reluctance at directing recommendation toward courts. Is that right, Matt?
I don't want to, I'd rather not open up this can of worms. I don't think, my reading of ACUS's record is that ACUS does not usually make recommendations to court on doctrinal matters as opposed to, say, rulemaking matters within the sort of jurisdiction of the judicial conference. That's my reading of the record, and there's very little evidence that courts give any stock to ACUS's opinions on what might be called doctrinal matters.
That is my view, but
I agree with Matt.
Okay. So if we were to strike it, we would just stop in the middle of line 45, and then all the highlighted material would be stricken. But comments on the idea of just eliminating the issue. Jillian Metzger.
Hi, thanks. I think I understand the concerns about the great deference. I think we can play around with the language. I think there is a benefit for including something along these lines. The background concern here is that agencies will be dissuaded from doing something we think is quite beneficial and transparent and accountable and accessible by fear that they will find themselves in court as a result. To simply have something in there to sort of counter that by saying give due consideration seems to me pretty innocuous and to serve a fairly good function. So I guess I would prefer to keep something in.
But more along the lines of due consideration.
Can I speak? I seem to have lost the capacity to use chat.
Please go ahead.
I'm looking at the relationship between this and paragraph 7, and they ought to be made parallel. And I rather like, I think it's consistent with what has previously been said, that it's not an agency that does not wish to be bound so much as an agency should explain the way in which it should explain with reasons the way in which it intends its rule on rulemakings to be taken.
Yeah, I think the language is consistently clear on that distinction throughout in the revised version is my take.
It's not the way the said both. Well, the suggestion that was made was that there be a discussion and not simply a statement. Don't provide for any rights in benefits, substantive or procedural, in this rule, and there could be more flexibility than that.
So you'd like to expand upon the list of
well, I would
disclaimers?
Think in both paragraph 7 and here.
Mm-hmm. Recommendation 7.
Recommendation 7, yeah, well, it says paragraph, but in both recommendation 7 and here, what ought to be done is to have language like Don's, without regard to whether courts should give great deference, but rather what agencies should explain in their rules on rulemaking.
You mean substantively, or you mean with respect to what is a court, what direction to a court?
It's not a direction, in other words, not make a direction to a court.
I don't know. Todd, what's your reaction?
I'm happy to. So the language that I heard from Peter was that the language should be something to the effect that the agency should explain the way in which its rule on rulemaking should be interpreted with respect to. Peter, what would you?
I was trying to mirror the comments that had earlier been made, I think by Steph, but I don't remember the name exactly, about reasoned explanation rather than simple flat statement.
From the severability.
Would you like me to repeat that?
Yes.
Okay. It was agencies should likewise address, I don't know if we need the likewise, I'm missing the context on the severability clause, but agencies should address their determination of that committee use severability. We would presumably use judicial reviewability in the text of the final rule and provide a reasoned explanation for that determination in the statement of basis and purpose. Agencies should address their determination of judicial reviewability in the text of the final rule and provide a reasoned explanation for that determination in the statement of basis and purpose.
Something like that. And also that would also go in, that would also change recommendation 7.
So I think we have some of that material in the sentence that leads with as paragraph 7 below provides, a recommendation 7 below provides, but I guess we could slightly modify that. What do folks think about that general direction?
This is Steph. I do think there's a benefit to telling an agency that it should explain its reasoning, because I think that is part of what will help it to get deference if that's its objective.
Sid Shapiro.
Thanks. We covered this in 7. We can put off there whether we want to change that language. Here, we're just kind of a precatory statement of how the courts might treat that. And I think Peter was suggesting we just tie them up. So maybe the due consideration should refer to the agency's statement and explanation of why it does not regard these as enforceable rules. And that'll tie the two up.
That's how I understood Steph's language to work, would be with respect to the statement.
Right, but I would keep the due consideration. I would say something to the courts, as Jillian suggested. Oh,
I see. You keep both parts.
Yeah, and reference that whatever we say in 7, because that's what we're asking the courts to give due consideration to, the agency's reasoning rather than characterization, how they explain themselves.
Further comments?
Connor, what is the, I'm just curious to know, I understand in the severability context what an agency might say by way of explanation. What would be contemplated here by way of an explanation on this question?
Todd, did you see examples in the 5 or 6 that you found where there was an explanation?
No, there were no explanations. There was just a disclaimer like we saw in DOT. It said something to the effect of, this rule does not create any rights or benefits, procedural or substantive, enforceable at law or in equity. Some variation of that across the 5 agencies.
Got it. So it's stock boiler. Okay, that's interesting. I mean, that's a good point, Matt. And I sort of read that language as a way to sort of nod at the judicial review question indirectly, but that's a good point. If we don't have examples of that, then maybe we ought to be careful about adding language that no agency has done to date. Comments on that? Comments on whether, let's divide this into 2 issues. Issue 1 is, do we want to add language along the lines of the severability recommendation about agencies providing a reasoned explanation? And so let's just take a quick show of hands. Those committee members who would like to include that type of language that we can include for the Committee on Style, raise your hand. 1. Todd, can you help me?
Yeah, I'm looking right now. So Peter, okay, so I see, let's see, I have, okay, Alice is 1. Sid, Peter, I think, had his hand raised.
I did see that.
Jonathan Doles is 4. I think that was it. Am I missing a committee member? So that's it on the screen. I'll see if there are any that are in the chat. I don't see any votes in the chat.
Okay, and then votes against including the reasoned explanation language for agencies from committee members.
Oh, I think, Connor, that's a vote against?
Yes.
Okay, I see 1 from Michael Livermore, so that's 2. And then Danny Fischler is 3. And I'll see if there are any in the chat. Elliot Laws is 4 against. So it looks like we have so far 4 in favor and 4 opposed. Erica Litzen just said that she joined, but is not voting on this because she didn't hear the full discussion on it.
Did you get Elliot Laws' vote against, Todd?
Yeah, Elliot was a voting.
Okay. Got it. Okay. So in the event of a tie, motion fails. Thank you for Elliot. Sorry about your camera. So we will not include that language. Jillian, I see you have a comment. Jillian Metzger.
I do, but I'm not actually sure where we are. So I'll make it once you figure.
Okay. Well, sure. The second question is, so with respect to the second question, is do we want to include something along the lines of Don Elliott's language? And if so, do we want it to say something like deference, or do we want it to say something more innocuous, something softer, like due consideration? So let's just go ahead. Any additional comments on that question of, do we want on this last line, what's on the screen 46 through 50, do we want to include something about great deference, due consideration, or nothing at all, and leave it off as Matt Weiner has suggested?
Can I just jump in here on a technical matter? Todd, do we have, Jennifer's dealing with one of our members in terms of being connected. Do we have people, especially committee members, who are being excluded, or who are excluded from this discussion because they're having technical problems, or we don't think that to be the case? I did hear from one member to that effect, and that's why I'm raising it.
All I know is from what I see in the chat, and I've seen some mentions of technical problems, but I don't know how widespread they are.
I see 35 attendees right now, including a number of committee members, but I don't know if anybody's unable to speak or not. In the interim, I think Bill Funk and then Jillian Metzger wanted to speak on this.
Yes, thank you. I wanted to speak in favor of some sort of language in this regard to giving consideration by courts or deference by courts. I agree that ACUS normally doesn't and shouldn't give directions to courts in its recommendations, but I read this really more as hand-holding for the agency by ACUS saying, you shouldn't worry too much about being held accountable in court on this if you say you don't want to be. I mean, I think agencies may be reluctant to do something that might bind them where they didn't intend it. And I think if we include some language supportive of the notion that they shouldn't be held accountable or judicially accountable would be helpful.
Thank you, Bill. And then Jillian?
Bill said what I was going to say better than I would have. So.
Okay. Before we take a vote on this, I see Peter has suggested voting order, but any other comments on the idea of what to do at lines 46 through 50? Okay, go ahead.
Yeah, this is Jonathan Weiner. So I apologize, I had to step out for a minute and come back, but if the problem is the ACUS recommendation being addressed to the courts, asking the courts to give deference versus advising the agencies, have we already dealt with that and removed the recommendation to the courts? And then the second question I have is, why not just make this a description rather than, this is a recommendation before the recommendations, this sentence. And recommendation number 7 makes the recommendation. So this sentence could be rephrased as a description of if courts enforce it, or if agencies, then agencies may be discouraged. 2 thoughts.
On your first question, Jonathan, we're discussing exactly that question, whether or not to include something to the courts. Bill Funk says there's language to solve this.
Yes, in order to avoid giving a recommendation to the court or a recommendation in this language, we could merely say that ACUS believes that courts are likely to give deference to an agency's contemporaneous explanation for how they want this be handled, or not to be governed, be held judicially accountable. In other words, to say rather than we recommend, we say that ACUS believes courts will. I mean, it's a characterization of the way we view judicial doctrine. I think it's an accurate statement of judicial doctrine.
So make ACUS the speaker. Reactions to Bill Fung's proposal.
Hi, I have a reaction to Bill's proposal, which also ties into this larger point generally. To the extent that we're concerned that what we're saying here is not going to be persuasive, we might just want to add a case cite. I'm happy to provide one if that would be helpful, but there are cases, dealing with procedural rules specifically where courts have credited these kinds of disclaimers.
Could I speak? Jillian?
Connor, I think we lost your audio again. Can you? Yeah, we did lose your audio. So I will send you the phone number for you to call in.
Can everybody hear me now?
We can hear you.
Sorry I did not know the problem. Rylan, thank you for that point. I was just saying Todd has added a couple sites along those lines. But Todd, you can direct us to exactly where those are, but Todd is researched that and added some sites on that point.
Exactly right. There are already sites there to that effect.
Jillian, I'm sorry, I was trying to recognize you, didn't realize no one could hear me.
Sorry, yeah. So I just wanted to speak. I mean, if the sites are there, I think it's fine. Peter had the point earlier about maybe we should do due consideration first, because I think from what I was hearing, there was more comfort with due consideration than great deference, and I think that might make a difference. I myself think that the statement, whether it is in terms of courts should give or ACITS believes that courts will give due consideration is perfectly fine and encouraging. I would not myself shy away from saying courts should give here because of the point that I thought Bill said well before, that really this is this is in the precatory part, it's not really in the recommendation part, and it's really speaking to agencies. And if we put in a couple of sites, I think it takes care of the concerns. In terms of the case law, my only concern is that my sense, and Todd, you would have the better sense of this, I'm sure, is that the case law can sometimes be a little bit inconsistent. Some courts give more deference than others. And so I'm a little bit concerned about ACUS coming out and saying we believe very strongly when there is some variation in the case law.
Todd, did you have any thoughts? I see Rylan sending around some sites, and the committee on style can, if we want to supplement sites, that's great. But Todd, did you have any responses to Jillian?
No, other than to say that Jillian's characterization is accurate. There is variation.
Yeah, and you had kind of mentioned that. This is a little bit tricky to know how to vote because we have a number of different ideas. But I would first call for a show of hands for those who support Bill Funk's direction of sort of putting the belief in ACUS. So all in favor of the Bill Funk, and the committee on style can clean it up, and we will send a recommendation at the end.
So just before we vote on this, I had kind of put myself on the queue just to offer an alternative.
I'm sorry, I missed you. I'll go ahead.
Yep. So This would just be, if we're going to be characterizing the case law, one place we might want to do that, be more comfortable, would be in footnote 5. And so we have an example now, and then, you know, there could just be some follow-on language there where these case sites go, and you know, pin sites, and some kind of narrative discussion of, you know, how courts can and perhaps should treat this kind of language, and perhaps it just would be more appropriate in a footnote than in the main text.
So you're thinking add some sites and additional guidance in the cement kiln footnote? Am I hearing that right?
No, sorry. I was having trouble reading that.
Above that, right? The 49 CF.
Yeah, exactly.
And then add showing the deference, the deference case.
Right, the deference cases would then go in there.
Oh, I see. Reactions to that proposal.
Is that meant to be in lieu of having it in the text? In other words, put the sites and the comment that we believe the courts will generally give deference. Is that all going in the footnote, or?
That was my thought.
Okay. I would prefer that. And it seems like a good place for it.
So it seems like we have maybe 4 different directions. Matt, you've called many votes. Do you have a sense of the right way to vote on this with 4 different ideas on the table?
No. In short, no.
Thank you, Matt.
No. Reeve, you have any ideas here?
Not really. I mean, I think, yeah, we probably just have to go through the 4, although it seems like, assuming they're all, you know, full alternatives of each other, which they seem to be conceptually, but I don't really have any suggestion as to the best way to do it.
Is it clear that there's not, is it clear that we can't reach, or not we, the committee can't reach consensus on this point? Without
that would be great. I have not sensed the consensus because folks have spoken a number of different ideas, but I'll just run through them. Is there a consensus? I'll just go in the order that they're in my head for the Livermore, addressing the issue with a number of sites, and what is footnote 5? Is there objection to that?
This is Dan. So it strikes me that whether I have an objection to that really depends on what the footnote looks like. I thought that the benefit of the text in the preamble portion was that it made a recommendation to courts, and putting in a C site with an acknowledgement of uncertainty as to how these would be honored might be something that I would not vote in favor of, but it would depend on the specifics.
How about with respect to?
That's the issue here, Connor. It seems to me there has to be agreement on what the text, roughly what the text of the footnote's going to be.
Yeah, Mike had sort of sketched it out, but it's tough to get it all up on the fly. So do we want to, Mike? Do you want to try and give it all the time? We'll put it down in footnote 5, and then people can look at it closely.
You may just try to draft something up and put it in the comment section. Okay,
yeah. Down in footnote 5, literally is a red line down in footnote 5. Then people can see it. And we can do our best.
Right. Do you want me to input that into the comments, or do you want me to send it to Todd?
If you want to just send it to Todd, or whatever you say, Todd.
Comments would definitely be better. I don't want to pull up my email on here. So.
Okay, I'll try to do that.
Okay, thank you. Send it to Todd. That's better. Thank you, Todd. While we're working on that, we can go back to that. Let's go to the Bill Fung suggestion, which would use ACUS's voice with respect to ACUS believes courts would give. And Bill, did you want to say due deference, or what description did you want to give with respect to the agency's characterization, Bill Fung?
I don't like great deference, but I don't have any particular you can vote separately on whether it's due consideration or deference. My real point was only to make it ACUS's voice rather than might appear to be a recommendation. That's all.
Got it. Do we have objections to using ACUS's voice as opposed to the court? So objections to using ACUS's voice. My own sense is that might keep us out of trouble at the plenary session, which is worth something. Okay, then do we have objections to using due consideration as the description for deference? Or do folks prefer to use, I'll just say, do we have objections to using due consideration?
Sorry, this is just to take it. I think it's weird to say that we believe that courts will give due consideration. I mean, that just strikes me as totally weak. I think we would either believe that they're going to give deference or we think they should give due consideration, but the believe will give due consideration that just seems like a nothing burger.
I see our Vice Chair chuckling. Okay, reactions on that. Peter Strauss.
So this is more or less going back to where I was before, but rather than talking about the courts giving due consideration or great deference, to me, the work of this sentence ought to be, particularly with the footnote that we've been talking about, the work of this sentence ought to be agencies should carefully explain in their statement of basis and purpose their characterization of whether blah, 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 blah.
My concern with that, Peter, is that we don't have examples of anything more, agencies using anything more than boilerplate, and we had half the members of the committee who voted didn't want to go in that direction. So we could take that up again at the plenary, but I think the committee leaned against going in that direction.
I'm part of the committee. I don't remember leaning, but okay.
Yeah, the vote was 4-4.
This is just on this potential language for the footnote, and it kind of is really, so one way to maybe say something like this is a little bit more applicable. Something like agencies could be discouraged from promulgating rules on rulemakings if courts were not to defer to agencies' characterizations of whether a particular rulemaking is judicially enforceable, et cetera, which gets to the point that I think Don wants to make here, and is a little bit like a should statement, but not fully. It's more of a kind of a prediction. It's kind of more of a, it's a downside that we're being explicit about, and then perhaps then we could put in the CF and some citations where courts do in fact defer to these kinds of, at least similar agency statements.
I have some reluctance about ACUS sort of predicting how agencies would react to court decisions. It seems like a lot of if-thens, but what do other folks think? I see Danny.
Thank you. I previously expressed hesitation about the footnote. If the footnote said this, I would support it. I like this formulation. And from the perspective of like, if I'm thinking about how I would talk to my leadership about a rule like this, I think the statement is simply, to me, it's true. It seems factually accurate with respect to how my leadership over the last like 10 years would react to something like that. My only proposed change would be to put it in the main preamble rather than a footnote. But otherwise, I have nothing on it. Thank you.
Opposition to, or anyone opposed to the footnote 5 as drafted in concept. Obviously, committee on style we'll clean it up. But opposition to the in concept as drafted footnote 5. My sense was the committee wanted to keep it in footnote. Anyone other than Danny speaking strongly in favor of moving it up to the preamble main text?
I think that makes sense as a substitute for what Don had proposed.
Additional comments on this? Okay, hearing none, we will have the Committee on Style build this out, but we'll use this as our direction. Does that give you enough, Todd?
Yeah, I'm not sure it does. That's why I just wanted to clarify something.
Please,
So
go ahead.
if we're going in the direction of this footnote, I just want to be clear on what the committee thinks should happen to the above the line text in this paragraph. So I guess what that would mean is that all of this language here to avoid Don Elliott's language would come out, and as would what's currently struck through. And so it would just be this up to footnote 5, and then what we've decided on footnote 5 there. Is that right?
That's my understanding.
Yeah, that's
Okay.
what I was in. That's what I was envisioning.
All right, great. Then we're good.
Okay, then we will move on to recommendation 1.
Rest assured, Connor, that this will get revisited, reopened at the plenary session. So I don't think anybody should feel too bad if they didn't get it drafted exactly as they want to.
Yeah, I was trying to kind of give Peter a nod in that direction. Recommendation 1. Any comments? Okay, so recommendation 2, the committee had worked hard on creating these buckets. The idea here is to not create an extremely long and unwieldy list. One other idea is that to the extent that a list is too long and purportedly non-exhaustive, some may still view it as exhaustive, and so to the extent we miss something, that can be an issue. So the shorter the list is, the more it truly seems non-exhaustive. The other goal in keeping it shorter is so it's usable for agency folks who, you know, in the real world may not be plowing down a 25 or 30 item list. So those are the goals, and that's based on the committee's direction from the last meeting in putting this together. So I will open up recommendation 2, and Peter, you had submitted some amendments. If you want to speak to those, please do.
Well, all of them are introduction of additional examples, and the motivation of the particular examples that I chose were things that I thought the public ought to be particularly interested in or concerned about.
Reactions to Peter's suggestions and additions.
I had one reaction on item 2E. The addition seems like it belongs more logically in 2B. I was thinking with respect to internal approval procedures for issuing and finalizing rules that would have more to do with internal review chains and that kind of thing.
I'm not sure I understand.
Like, so I view the treatment of post-comment period communications as related to procedures connected with the notice and comment process, item 2B. So I would move that example potentially up there to item 2B. This category of item 2E, internal approval procedures for issuing and finalizing rules, I had understood that category to relate to, for instance, if an agency were to say that their general counsel's office reviews all rules for legal sufficiency before they're finalized. That was how I took that category as relating to sort of what the agency does internally, rather than how it deals with comment period things. I thought that fell in category B. But if people understand these categories differently, that's fine. It was just
I did understand it differently. That is, okay. I understood 2B as dealing with the period of time between the notice and the end of the comment period, and 2E as dealing with things that happen after the comment period ends. And I actually, one of the reasons for having treatment of post-comment period communications in there that might appeal to people is that there's this strong ACUS and well-regarded, well-implemented ACUS recommendation on that subject.
Yeah, I didn't take the list, Peter, as chronological because we have 2D as reassessing existing rules. So this could be clarified, but I had a similar reaction to Danny's just in terms of what the bucket stood for. Jeff Lovers?
2D and 2E. I would just make 2D into 2E and 2E into 2D.
Mm-hmm. I think Jeff Lovers is in the queue.
Well, thank you. As to 2B, I would suggest adding at the very end of the paragraph, and use of reply comments. I also think that Peter suggested an A, which I support the reason for it, regulatory plan processes. That's a little too cryptic, I think, for a lot of people. They have to know what the regulatory plan is. So maybe, I don't know, participation in the regulatory plan or something like that.
Anjali, I didn't mean to miss you before. Did you have a comment?
Yes, I think a couple of us had an issue going back to line 33 on page 2, just to replace the pronoun it, because the lawyers are going to know you mean rules or rules on rulemaking or such a rule, but not everybody would know.
Can you just read the sentence? Okay. The line numbers have changed. What can you just say the sentence and I'll just control F it?
Sure.
Go ahead. Go ahead. In promulgating a rule on rulemaking, an agency may wish to solicit public comment to inform its development, even if it is subject. You want to put the agency instead, is that right?
No.
Instead of it, we could put such a rule.
Such a rule.
Okay.
Thank you.
That seems unobjectionable to me. Back to recommendation 2, Jonathan Doles.
Sure. I would recommend that we change it to the term regulatory planning processes to something like regulatory planning. It's a little too close to the reg plan that we use for unified agenda purposes.
That would be fine.
Alice Kottmeyer.
Right. I have a question about 2E, where it says treatment of post-comment period communications. First, I don't know what treatment means, and I'm not sure what communications means. I'm not sure what is being proposed here or recommended here.
ACUS has a broad recommendation about how agencies should treat what are sometimes regarded as ex parte communication that are received after the rulemaking record has ostensibly been closed. And the intention was to refer to that set of issues.
Is there going to be like a drop a footnote or what?
Well, we don't have footnotes and recommendations, but
that's true. You don't.
If one wanted to put a footnote there, one could.
It would also include how to handle comments filed after the comment period, after the close of the comment period. Not just things that come over the transom, but things that were meant for the comment period. But
absolutely.
Late filed comments.
Okay. And if we needed to, if a member of the public wanted to present a petition for rulemaking, is that included in one of these A through E? Possibly D, I guess.
Or A?
Why not A?
and A.
Okay, petition for rulemaking would be included in procedures prior to the issuance of the notice.
I think we should add it more explicitly.
Yeah, because that's one of the reasons why state did its rule on rules, which is currently still at OIRA, because we don't have any rules on how to deal with petitions for rulemaking. So we wanted to add that to our 22 CFR. So yeah.
Connor, can I jump in here for a second?
Please do. And if Reeve, if you have thoughts on the general issue too, please, but go ahead, Todd.
This is the general issue. So you can probably add easily hundreds of discrete actions into this list. And if the committee wants to, it certainly can. I mean, that's the committee's decision, but I'll just say I think what we intended by drafting this section was taking what the committee wanted last time, which was a grouping and a manageable grouping under which a lot of these issues could fit. So we could certainly add a lot more examples to this, but I think that would defeat the purpose of having a broad list that's meant to be encompassing.
Reeve, did you have any thoughts on this issue?
And not really beyond what Todd is saying. I just want to sort of echo that point. That, you know, I think it's fine if we want to add the additional list of examples to each of these, but I don't think we want to sort of recreate the 26 item list that we had before, you know, in parentheses. I think that, you know, there's some virtue to the groupings, but I think we'll have to sort of pick and choose, you know, given that we're not including everything. So if we think there's value, you know, adding petition for rulemaking or the like, I think that's good, but, you know, I think we want to avoid sort of excessively lengthy parentheticals here that will sort of take us back to sort of what we had initially.
Yes, this is Alice again. I agree with that, but I think petition for rulemaking for the public might be a lot more helpful than regulatory plan processes, which are kind of arcane and in fact, the State Department doesn't even do a regulatory plan, so not all agencies do them. If we're talking about that, anyway, that's all I have.
Take them.
I love the new formulation. I think it's great. I also think that the examples can be helpful. And, you know, we've heard a couple of agencies, I think DHS as well, say that petitions for rulemaking was an area where they did promulgate this type of rule. So I would support the inclusion of that example. I was going to make a suggestion on E to address the sort of potential ambiguity about what we're talking about when we're talking about finalizing rules, which is just to suggest that we split those two concepts apart and address procedures for finalizing rules. And this is a very minor question, but I wondered if, since all of these are, you know, discussing procedures, if we should move the procedures into the chapeau for each of these points. So that was, you know, sorry to move too quickly on E, splitting the procedures for internal agency approval prior to issuance, and then procedures for finalizing rules. And then the finalizing rules would keep the example that was added by Professor Strauss.
I guess my read on E was that it's all about internal. Todd, was that your intent in drafting? It's all about internal?
Yeah, I mean, so this was actually, I think what motivated this one was the DOT procedures that, I guess, like the first few pages of the rule on rulemakings, which describes, as Danny mentioned earlier, you know, the general counsel needs to sign off on rules in this respect, and the regulatory reform task force has to sign off before a rule is initiated, and so on. All of those internal procedures that need to take place before a rule can be published, as you know, a proposed rule or a final rule could be published or sent to OIRA for approval.
Right, and then I'm wondering if, you know, is treatment of post-comment period communications the same thing as that, or is that a separate bucket? And I don't have a great recollection of how we recommend agencies treat those, but is there a public aspect of that? Like, do we ask them to disclose it, put it in the record? Because if there is, you know, if it is different than just the internal procedures, I guess I would continue to call it out as a separate issue.
I think that's separate. I think treatment of post-comment period communications would, as this was written, it would not encompass that example.
Might fall more under B.
This really depends, doesn't it, on how one understands coming to the recommendation, how one understands it. There was a suggestion in the materials that were circulated to us that there'd be a possibility of having an appendix. And one way out of all of this, because I think the buckets are terrific. I'm really pleased that the committee did that. One way out of all of this would be at the beginning, in the opening paragraph of 2, to state something like, and attached at the end of it, an appendix attached gives examples. And then you could take out all of the examples and have the appendix, and the appendix should certainly include petitions for rulemaking. In my judgment, it should certainly include the way in which the agency responds to the ACUS recommendation on how to treat communications that it receives after the comment period closes. It should include the treatment of reply comments and late filed comments, all of that. And one has it as an appendix. These are examples of the things that we talked about in A, B, C, D, and E without giving you examples.
Reactions to the appendix idea. And Rylan, I see you in the queue, and Jeff, I see you in the queue, but while we have the appendix on the floor, reactions to the appendix idea.
Yeah, that was going to be my comment, actually. I agree with Peter's comment. I think an appendix would be helpful. It would allow us to be comprehensive. And, to be frank, like the way the text is looking right now, it actually kind of confuses me why we're citing to those particular examples and not to other ones, and if that's meant to convey something or not convey something. And I think we should just get away from that altogether, have something very streamlined in the recommendation itself, and have our comprehensive list in an appendix.
Those any voices against an appendix?
Can you clarify, is an appendix considered part of the recommendation such that it is, the content of it is drafted and voted on and so forth, and it doesn't change, has the same sort of status?
I know we've done them before, but I'll let Matt or Reeve or.
No, there's ample precedent for the inclusion of appendices and recommendations, and yes, they are part of the recommendation. They are the recommendation. They are voted on by the committee, and they are published in the Federal Register. So yes, the answer to your question is yes.
Thank you.
I know Reeve had mentioned they're often done by way of explanation to give an example of something,
That's exactly what's proposed here. To replace the examples that are given now in in the subsets of the buckets with an appendix that gives a full set of examples.
To the extent we did go in favor of an appendix, would we want to start with the list that the committee compiled at the end of the second meeting, so the way the text read at the end of last meeting, or do people have a different idea?
It's a good starting point.
As long as we're going to use an appendix, let's give as many examples as possible, and the more expansive list was the one we previously had.
So as I understand, the proposal would be to strike all the edits that we had made. Jeff will, because I knew you have a thought, but strike all the edits that we have on lines 57 to 65, strike all edits, and then include an appendix that we had compiled from the last committee meeting. So
strike all paragraphs begin parenthesis EG.
I'm sorry, say that again, Peter, I couldn't hear you.
Strike every paragraph that begins parenthesis E period G period, and add at the end of 2, before you get to A, B, C, D, E, an appendix gives examples.
Can I suggest that although we go back to the full list that we had at the last meeting, that we retain the buckets, because I think the appendix will be easier to follow if it's structured somewhat.
Absolutely. I didn't mean to get rid of the buckets just to get rid of the EGs.
Yeah.
Okay, so there, what you're saying, Peter, is there are a few EGs that are not in red line, so
correct.
Remove those as well. Okay, so opposition to, yeah,
sorry.
Todd. Or Matt, I'm sorry, please.
Oh, I can, I just a process question here. I think what the committee settled on based on Peter's recommendation is an excellent approach. Process-wise, how do you want to handle this? Do you want the staff after this meet? I mean, maybe you want to take this up at the end, but would the staff after the meeting draft the list based on the prior list, and then any additional suggestions committee members have, and then the committee would address that by some kind of email vote or something? How would we handle that process-wise? Because it doesn't sound like we're not going to hammer out the list right now on the phone. Doesn't sound like.
No.
That approach would be fine. The other approach I thought was to just try to leave the list where we left it the last committee meeting, where everyone had a chance to weigh in, and then to the extent folks wanted to add stuff, add it to plenary was my kind of preference.
Okay, I just didn't know if there were additions to the list, the last list, based on this conversation, or comments that committee members had in the written comments.
So
let's open that question up.
I think we should make sure that everything we added today also appears on that previous list, if it doesn't already.
I believe it all does, Todd, but we have to check that.
And I also have one other comment, which is, even if we're just going to leave the buckets here without the EGs, I still think we need a new bucket, a new paragraph E in between, before the internal approval procedures one, because I think we need one that says something like procedures for handling post-comment period communications and communications period. And then that would be something that we could elaborate on in the appendix, and just make sure it includes ex parte communications and late filed comments. And maybe you could put, well, so because
if we did include that, I'm sorry, Jeff, if we did include that, I want to move that up before C or after C, but before D, to keep it more chronological.
Okay, I'm just pointing out that the F now is the only one that is entitled internal approval procedures. All the other ones are just procedures, which are more external facing.
Yeah, I read B as in boy to include the post comment period as well. But what do folks think? Do folks want to add a what's now D for post comment period communications?
Well, it's not in the notice and comment process per se. It's after the notice and comment process.
Or it's just connected with. So I read it as encompassing.
I guess I don't care that much about
it. Do we have opposition to including a bucket for post-comment period communications? And welcome thoughts from Matt or Todd or Reeve as well. Okay, hearing none, no opposition. Let's leave that in the draft then. So what we'll do then is, if anyone opposes this, speak up. If the plan would be strike all the EGs, include language, the command stack can include language before the colon that refers to the appendix. So that would, Todd, that would be on line 56. There would be language referring to the appendix. And then the appendix would include everything that the committee had added last meeting. And if we missed anything that's currently in the EGs on the screen, we would add that. So that's the proposal. Does that make sense to everybody? And if anyone opposes it, please speak up.
Oh, Connor, no, I just want to clarify, I want to make sure that there are no unresolved issues in the buckets themselves. So I think just the one thing that I'm not sure has been resolved is whether is G, or it probably has been, and I just didn't capture it, but internal approval procedures for issuing and finaling rules. I think staff had a proposal to split that up into internal approval procedures for finalizing rules and then internal approval procedures for issuing rules, but I don't know if that's quite right.
Todd, I think Jeff's edit has solved my suggestion, so we could leave G as is and support the inclusion of the new D. I think the numbering's a little off, but you know what I mean.
Okay, great.
Any other? Okay. Let's move on to recommendation 3 with respect to accessibility. Recommendation 3 on Todd's screen, line 69 through 73. On your other file, 68 through 72. Todd, did you have a note? I'm just reading this. Did you have a note to the committee on recommendation 3 that you wanted to expound upon?
Yeah, so the question here is whether we should say anything in this recommendation in numbered paragraph 3 about publication in the Federal Register or the CFR. So we currently say agencies should put these rules on rulemakings on their websites, and the question is, do we want to add this additional element to the paragraph?
We cover that in the preamble. Views on that question?
If you are going to do that, it should be clearly in the permissive sense. Should make the rules available in an easy to find place in the portion dealing with rulemaking matters, and may, as appropriate, place them in the Federal Register and or the CFR.
Reactions to Peter's.
I'm happy with it as it is.
Anjali, you agree with Peter's drafting or with the original suggestion?
Yes, I agree. If you're going to put something about Federal Register publication or CFR in here, I agree it should be permissive, and Peter's edit addresses my concern. Thank you.
Other views on number 3? On this question, I should say, on this question. Do folks prefer the permissive as drafted by Peter, staying silent, or staying silent?
I prefer the way it looks right now. I'm also okay with Peter's suggestion. I would just note, though, that the rest of this recommendation is talking about things like tabs and menus, which apply to the website and don't really apply to the FR or the CFR. And the second thing I'd say is, going back to our discussion the previous time, there are legal effects potentially connected with publishing something in the FR or the CFR. So I think publication there is not just about making things easy to find. There's a lot more involved. So I guess I would prefer the way it is right now.
There's a middle ground, which is just to mention the Federal Register at the end of the paragraph.
To keep the website point.
Yeah, not the CFR.
Mm-hmm. The underlying recommendation that this is sort of drawing from does talk about Federal Register and CFR. Am I right about that, Reeve? So, sorry to put
What was the question?
I was just saying the underlying ACUS recommendation on publication of guidance that we did a year ago, where this is, I think, kind of drawing on, mentions both CFR and Federal Register, I believe.
I thought it maybe just mentioned the website. Let me go back and Todd, do you recall?
It did mention.
That was.
I'm like 80% sure that it mentioned the Federal Register. I'm not sure about the CFR.
I've got it right here. It says, or in the Federal Register or the CFR in recommendation 4. So it says both. So using a permissive Federal Register or CFR would be consistent with the I'm referring to public availability of guidance documents from June of 2019. Would folks object if we mirrored that language in the permissive along the lines of what Peter suggested? Other comments on recommendation 3? Hearing none, we'll move to recommendation 4 on explainers.
Wait, Connor,
Just 1 second.
Yeah.
So we can put this at the end of the text of 3 rather than at the end of the first sentence?
I had understood Peter's suggestion to be at the end of the first sentence and then diving into websites in greater detail, but welcome comments.
Well, then we should amend the second sentence to say agencies should use techniques on their websites or something like that.
That seems appropriate. I didn't mean to cut off discussion on number 3. Additional comments on number 3. As I said, we'll be sure to send this all around after we finish cleaning it up. But the idea now would be at the end of the first sentence of 3 that we include Peter's language. Recommendation 4, we have a proposed edit from Peter Strauss. Peter, do you want to speak to that? Line 74 to 76.
I'm unmuted. Sure. This is all about explainers. And so I thought that it should be framed in terms of explaining. So providing a generalized explanation, this isn't a rule, of how the rulemaking process works to educate the public. Without setting forth any procedures that the agencies will follow strikes me as surplusage.
Todd, did you have any reactions?
No reactions.
Any opposition to Peter's changes 74 through 76?
Can I just ask a question? What does generalized mean in that context? How is that different from, I just want to make sure I understand what the substance of that addition is, rather than just providing an explanation. What are we trying to say?
It's for public consumption at a relatively easy level. I certainly don't insist on generalized.
I just didn't know what it meant.
Yeah.
Other reactions on anything in number 4, 74 through 81? Okay, hearing none, then we'll go to recommendation 5 on citations. Todd had noted we sort of had this is lines on Todd's screen 82 to 83. We sort of had a inconclusive discussion about citations. With DOT, I remember noting that they generally do cite these. Some agencies saying they don't. So we opened number 5 up for discussion, noting we didn't reach consensus the second meeting.
Connor, I'm sorry, I was muted. I was trying to say something about the previous recommendation. The word generalized, I think.
Okay, yeah, I tried to give a long pause, but go ahead, we'll go back.
I think what we're trying to say is sort of easy to understand or
exactly.
Accessible.
So
how about saying should, rather than providing an explanation, how about just explain in an accessible manner or something like that, or in accessible language, or
agencies should consider explaining in accessible language how the rulemaking process works to
Nothing
educate
like
the
that.
public. Fine.
Yeah, okay.
Any opposition to the languages in the comment level? Okay, going back to the number 5. Comments about how to handle citations. I just noting DOT said they generally do cite these, some agencies don't. Comments on number 5.
I would prefer not to have comment 5 because it seems to be suggesting, oh, you ought always to do this. And I can't imagine that that would have much meaning if it happened.
I agree. It also implies that there's some legal effect for doing so.
Yeah, yeah, I tend to agree. It strikes me as an odd recommendation for those reasons.
Does anyone wish to speak in favor of including number 5? Hearing none, we'll strike number 5. Number 6, we'll start with Sincha Pyro's proposed edit.
Yeah, last time we had 2 recommendations that referred to other mechanisms, and one spoke more in a sort of explained why you might want another mechanism. And I thought the language just, if we limit the language, if we only have the language, some other mechanism, it's so general and vague that I'm not sure anyone will know what it means. So I thought the intention was to enable participation by marginalized communities affected by a proposed rule. But perhaps we had another purpose in mind, but that's the one I had in mind.
I forget, did we originally have the word underrepresented?
Yeah, we might have. I couldn't find the former language, and that may well be what we said.
Yeah,
How do you feel about that word, Sid?
Right.
Sorry,
yes, that's fine. Absolutely.
Go ahead, Todd.
Yeah, so that language initially appeared in the list, in that long 26 item list that appeared in recommendation 2. I don't remember whether it was also repeated here. I don't think it was. I think it was just in that list, which is now going to be in the appendix. So that's where it appeared in the previous version.
And that's why I suggested combining it with the language that is in 6 to make that very direct connection as a recommendation, rather than have it lost in an appendix.
Views, reactions.
Making a different point. I mean, I think Sid's point is that we should add this to 6 because, you know, we want to get put on rulemakings. The list was about what agencies would do in their rulemaking. So I would support Sid's idea of adding something like that in this recommendation.
Other views.
This is Riley.
I thought we were going to change the language to underrepresented rather than marginalized.
Rylan, I agree, Sid. Rylan, did you have something?
Yeah, and I'm sorry if I'm just being kind of slow here, but when I read the original text, you know, without Sid's addition, some other mechanism, so what came to my mind were things like the agency can do a workshop with regulated entities or engage in, you know, early consultation or engagement with affected states or tribes or communities. And I feel like the language that's been proposed here, you know, limits what some other mechanism means to something specifically about underrepresented communities. And I would prefer not to do that here, because I think to me, the point of this recommendation is to say that even if the APA doesn't require notice and comment, agencies should still go seek public input. And by the way, there are other methods of seeking public input besides notice and comment. I would be okay if we want to, list underrepresented communities as kind of a example, but I wouldn't want it to kind of, limit other possibilities for what those other mechanisms could be.
Michael Livermore.
So I kind of generally agree with that. Just a couple other tweaky things. I think the language now, Sid's language, might imply that the notice and comment process can't enable participation. So I would just change some of this to like whether through notice and comment or additional mechanisms or alternative mechanisms, or supplemented by alternative or additional mechanisms that facilitate more robust participation, and then maybe by a larger or just more robust participation might be sufficient, maybe flagging in some ways underrepresented communities.
What Todd put that up on the screen. While Todd's doing that, Sid, did you have a reaction to that approach?
As it now reads, it's fine. As to, I guess it was Michael Livermore's suggestion that these techniques might be used elsewhere, and to good effect. I think that's probably correct as well. And I don't oppose enlarging it, but I guess I do oppose not mentioning underrepresented communities. There is an ACUS representation older than the hills on this from the 1960s. So it is the position of ACUS that agencies should consider how to bring in underrepresented people.
Prashant, I think I missed you before. Were you proposing to cite one of the executive orders, or what was your thought? Danny Fischler.
Sorry, I'm just a little confused about the construction of the sentence. Is there a word missing on the screen between the word comment and the word supplemented? Or should the word whether at the beginning of the parenthetical be struck?
Yeah, there's some wording problems here. These are, I guess, stylistic issues, but we could try to play with it now. It's hard to get it just grammatically correct on the fly.
Is the general concept that we're now not providing a range of options? We're saying notice and comment that we're recommending agencies should consider notice and comment supplemented on these rules?
Why don't we, I'm sorry, I didn't mean to step on someone.
No, go ahead, please.
When we say facilitate more robust participation, can we put the word just including? By?
That makes sense to me. I'm still a little confused by the whether, though, the way that the whether and the supplemented interact in the sentence.
I have thought we were talking about whether notice and comment or alternative mechanisms, and not necessarily, having to do both at the same time, although obviously an agency could do both.
That's correct. Whether probably can drop out now that we changed it to supplemented with rather than or some other. Whether and oh some other went together.
And then we would strike.
You could also do like an EG there, EG through notice and comment, supplemental alternative mechanisms. Maybe, does that?
Right, because otherwise it is saying should consider doing notice and comment plus, which and we're not meaning to be that prescriptive, I don't think.
Then the idea is we would strike the language in brackets, starting with the which at 86 through proposed rule on 88. Is that right?
Yes.
Do you want to strike that just so we can see the language as clearly as possible? Peter Strauss.
So there are all kinds of executive orders and statutes require agencies to reach out in their rulemakings to Indian tribes, to states and localities. One way of dealing with this would simply be to say agencies should consider a broad range of means for reaching out or for seeking public input on rules on rulemaking. Whether or not they're required to do so under the Administrative Procedure Act.
And then Peter, would you keep the EG in the parentheses after that?
Well, then you could say, sure, for example, by mechanisms that facilitate more robust participation, including by unrepresented communities, if people wanted to give that emphasis.
Reaction on that direction.
This is Steph. I have a suggestion. I agree completely with the idea that Peter has introduced here. I'm just wondering if, if it is an example, if it belongs at the end of in the draft that was circulated, line 37, where we discuss reasons for seeking input. And I think I like the formulation of the recommendation that uses public input as opposed to just public comment. So I would recommend in a preamble that we broaden the paragraph beginning in promulgating a rule on rulemaking to include public input instead of public comment there as well. So there it is.
Just to conforming change, public input.
Mm-hmm.
That seems fine to me, but comments on that potential conforming change.
What about the last sentence? It refers to public comment again.
Yeah, and I would move from the recommendation, the for example, into the preamble. So it would be after this last sentence. And then you could drop in some footnotes if you wanted to executive orders to, give examples of the underrepresented communities.
I caught it, but I don't know. I don't think I caught it. So what would go?
Yeah, in the recommendation that Peter just articulated for us, there are two sentences. So the first sentence is the recommendation itself. Agencies should consider a broad range of means for seeking public input on rules. And then he has an example. So I'm proposing to move that second sentence, which is the example, up to the preamble. And then we could, add supporting references to executive orders or other things if it were helpful. I don't have strong feelings on that, but it would provide an explanation for the recommendation being broader than public comment to include public input, and could give some examples of that in the preamble where we explain the recommendation.
I think that's a good idea.
Any opposition to moving that and then adding some of the executive orders in a footnote? Well, I personally like that because I think it keeps the recommendation clean, but adds the concept.
Along with the executive orders, we might cite the ACUS recommendation as well.
And the Small Business Act.
Sure.
Act. I mean, there are lots of things.
opposition to that or any views against doing that in principle? The specifics implemented by Committee on Style. Okay, Todd, does that all make sense to you?
Yeah, it does.
Okay. Okay, then moving on to recommendation 7, which is an issue we discussed in the preamble at some length. Comments on recommendation 7?
I'm sorry, I just had a very quick comment on the last thing we said. So are we saying things like small businesses are underrepresented communities, or are we just saying those are other mechanisms for more robust participation? I think I'm okay with the latter, but I'm not sure I would qualify them as underrepresented communities.
No, it's the latter.
Okay.
I would suggest adding the UMRA to that as well in that case.
Yeah.
Comments on number 7, building on our discussion earlier in this issue in the preamble.
Is this going to be, maybe I missed this. Is this going to be by way of is this going to take the form of a footnote, these citations? What are we doing? What's the committee doing?
Yes, there'll be a footnote to this sentence that goes up into the preamble, so there'll be a footnote at the end of the sentence.
I mean, it's, I just want to just point out for the committees, I mean, the presence of a footnote here is just going to occasion 10 minutes of debate at the plenary session.
I don't think
This will be a footnote in the preamble.
Oh, in the preamble. All right, I got it. I'm sorry. I missed that. Sorry.
The sentence will be moved up to line 32? Is that about right, Todd? And then we'll add the
yeah, exactly.
Footnote. I want to just any further comments on number 7?
I have a minor style comment. I know we were thinking of revising this paragraph to make it consistent with what we did in the preamble, but I just don't like the very end of it where it says any rights or benefits, substantive or procedural. Why don't we say any substantive or procedural rights or benefits?
It seems fine to me, Todd. You probably pulled that from some of the agency boilerplate, but it probably doesn't matter to.
That's the language that literally every agency uses, but we can be more concise than them if we want to be.
Eliminating a comma produces concision.
Well, not concision, I guess more colloquial.
Comments on number 8 with respect to flexibility.
Sorry, Connor, on 7, this might be something that Todd can pick up afterwards. Usually we use the word enforceable in disclaimers like that. When we use them, it'll say at the end of executive orders frequently enforceable law or inequity against the United States, etc. So we might want to add the word enforceable before the word substantive there in recommendation 7.
The word enforceable is there.
Right, it's in the beginning of the sentence as to the agency's intention. I mean,
right. I
at
see
the
what
end,
you're saying.
yeah. Thank you.
Yeah, I also wonder if there really is a need to get into like what specific text should be included. For instance, we could keep it more general and just say they should consider including a clear statement in the rule text that the rule is not judicially enforceable, and leave it up to the agencies to, use whatever boilerplate they want to use. I'm sure agency lawyers are quite familiar with whatever terms they want to use.
I thought in reaching consensus, there's some advantage and some merit to using the boilerplate so that we sort of have a focal point on which to suggest language, but I don't know, Todd, do you have a reaction?
No, the sentence was to hew very, very closely to the language that the disclaimers use, but that was just the reason for.
There is value in my view, and apropos, I think it was Danny's comment just now of not having, not implying. I'm not saying the language is a problem here, but not implying that this is in fact the language that agencies should be including in rules on rulemakings. I mean, that's a matter that agencies should be taking up with their offices of general counsel and so on.
Other reactions on this in this direction?
I have one.
Please.
I'm not clear why it only addresses court enforcement, as it were. I wonder if it shouldn't say affirmatively, rather that agencies should address in their rules on rulemakings the means of enforcement that they anticipate, hope, I'm not sure what word should be available. One wants to permit, perhaps even encourage, rulemaking participants to call the agency's attention to departures from its rules on rulemaking and give those some force, even though, and this is binding the agency versus binding the public, if you like, even though you wouldn't want to give them the right to go to court to get enforcement of it. So,
Peter, do you see some of that covered in recommendation 8, the next recommendation?
yeah, maybe what I'm saying is the 7 and 8 could be combined in addressing the enforceability or in addressing the legal character of their rules. Agencies desire in the internal flexibility to take a different approach than that set forth, should consider drafting the rule in a way that permits officials at a higher level. Agencies may include in there, or should consider including, a statement within their rules on rulemakings respecting their judicial enforceability.
Can we just say high-level agency officials?
Yes, sure.
Peter, just to be clear, are we not covering a concept as 7A is currently drafted that you think should be covered, or is it mostly desire to combine them?
From my perspective, which may be unique to me, the issue of enforceability or bindingness, if you like, is not an issue that is limited to the judicial sphere and could be addressed by an agency in its rule on rulemakings with respect both to internal means of assuring consistency with the rule on rulemakings and what they anticipate or wish to prevent in the way of external enforcement of the rule on rulemakings. And maybe that's unnecessary to say. The executive orders on rulemaking don't say anything except, well, you can't take us to court. But everyone who is subject to Executive Order 12866 perfectly well knows that it will be enforced against them internally.
Other reactions on this point?
I think Peter makes a good point. My only suggestion here, I can't see exactly what's on the screen, that if the committee is inclined to go in the direction that Peter is going here, that it agree on specific language here and not remit this one to the committee on style.
Mm-hmm.
Peter, would you want to add something to the beginning of recommendation 8, specific language? making clear your point that these things are internally binding? Would that help address? I mean, I agree with Matt. We should agree on language. But would that address your point to add a sentence at the beginning of 8?
Agencies should consider addressing the enforceability of their rules on rulemaking within the rules. If they desire the flexibility to take a different approach and so on. If they do not wish the courts, if they don't wish the rules to be enforceable in court on judicial review, they should consider adding a statement so that it becomes
Okay, so you would.
I'd combine them.
Yeah. What reactions to that?
I think I like the way it is currently, actually, because I had read 8 as talking about what if you want flexibility to deviate from the rule, which seems to be a little bit different than having some type of internal or administrative enforcement mechanism. In fact, it almost seems to be the opposite. I would not be opposed to adding language that asks agencies to consider addressing whether the rules are internally binding or enforceable in some way that's not judicial, but I just don't think it's really fits with what we have in 8 right now.
The binding character instead of enforceability?
I think binding is a word that often creates a lot of confusion. If we wanted to include internal enforceability or something like that, that might create less confusion. But my sense is agency rules are assumed to be binding on lower level officials. But Bill Fung.
Yes, I think it's important to distinguish enforceable in court from within the agency. And so I think 7 and 8 should be separate, not combined, and that 8 should specifically say addressing how the rule on rules shall be treated within the agency internally. Whether it's enforceable or binding or unbinding, that particular language. What's important is to say in 8, internally within the agency.
Peter, would that go some way to addressing your general concern? Is to just clarify that's what 8 is directed at?
Yes, and then what I would suggest is that you reverse the order of them so that 8 becomes 7 and 7 becomes 8.
To sort of address the chronological sequence.
And address the agencies internally first, and if you want to avoid it in court, second.
I see agreement from Bill Funk. Or other reactions to flipping the order and including a sentence that what's currently 8 addresses the internal. I don't want to use the word binding, but the internal bindingness of the rules on rulemaking.
You've used it.
I think it's fine to address that topic, but I guess I would just note again that this last sentence in 8, so what was there originally, to me seems to be talking about something different. It's not saying this rule is binding on agency staff or not binding on agency staff, but rather it's saying you can have a provision in the rule that creates a process for deviating from whatever procedure is set forth in the rule. And I think that's different from whether it's binding or not.
I read this as implicitly stating that the agencies should follow it at the lower level, implicitly saying that. But Todd, I don't know how you intended that in drafting it or read.
Just to finish my point, maybe it would make sense to, instead of having 7 and 8, having 7, 8, and 9, where 7 is talking about internally binding, 8 is talking about judicial enforceability, and 9 is talking about, how can you write your provisions in a way to create flexibility.
I guess I view the internal binding and the flexibility, at least from like Nick Perillo's report on guidance, is closely linked. But Todd, what's your view?
Yeah, no, exactly. So this sentence was really taken very closely from the agency, the policy statements recommendation, and the to some extent the interpretive rules recommendation. So there were, as many people here will remember, there were paragraphs that tried to get at this idea of flexibility and permitting alternative approaches, permitting the public to propose alternative approaches for the purpose of establishing the fact that statements of policy and interpretive rules are not binding. So this was it was importing that language of flexibility into this context.
So this is just a quick point on this. So I kind of agree with Roland's point that there are three issues that we're talking about here. There's issue about flexibility and the degree to which the agency wants to construct procedures to allow itself to depart from the rule on rulemaking under certain circumstances, which is just general. You could even have that and have the rule on rulemaking be judicially enforceable, where it's judicially enforceable subject to these certain exceptions. And so it's conceptually distinct. And then there's a second issue of I would just say the internal treatment of the rule or something like that. I would be more general in the discussion here, as opposed to it's very specific about a higher level agency official, lower level agency official. To the extent that we could just make that more general, that would be my preference. I don't have any language to propose though, so maybe it's and then there's the judicial enforceability. So I do like the idea of separating out the categories.
Other reactions?
I just wanted to speak quickly to Michael's point about the higher level officials. And I think I also got a little bit tripped up over that, because it is possible, and even for some of our own internal procedures at EPA, we do have mechanisms where you can have staff from various offices concur to waive a particular requirement. And that doesn't necessarily require a high level agency official to sign off on that. So I guess I would also suggest not being so prescriptive in terms of higher level agency officials here.
I don't read the language as trying to be prescriptive. I think it's just be clear about the idea that you follow it, unless the agency retains, to Peter Strauss's point, retains discretion to depart in the exception, which is consistent with the Perillo project. But
why don't we just say that permits officials to to take action?
I'm not sure that gives the agency enough guidance.
Well, then just say higher. Well, I don't think we can just say
matter.
Agency hierarchy.
The appropriate decision making or something like that.
My own sense is we could go with Peter's suggestion of reversing 7 and 8, a new 7 with an explicit statement that these things should generally be followed internally, and then including the language with respect to departures, and then going to the courts at number 8. That's my own sense, but I welcome reactions. Do we want to try, Todd, you want to try to reverse them and put a sentence that we can all agree on for a new 7 and move 8 down?
I'm going to do that right now. Give me.
Okay. Other comments while Todd's working on that?
Connor, we've been going for a while, and I'm having some sympathy for Todd doing this on the fly, do you think we might take like a 5 to 10 minute break and then come back to look at the language?
No, I think to Matt's point, people have a lot going on today, and I think we're just going to keep going. If anyone wants to step off, they can. But I'd like to just keep going because we're on the last one. So I think we'll keep going. But if anyone needs to step off, I understand that.
All right, so I did, so this is the language that Peter, so 7 is the revised, okay, I reversed the order of 7 and 8 and then changed 7 to reflect the language that Peter had proposed. So here it is, 7 and 8.
And then we would take out number 9, of course.
Right.
What work is the second sentence in 7 doing? Is that in lieu of 8?
So we would take that out.
So we take that out, yeah. Okay.
Would we be able to, just echoing the conversation from before with Ryland and Michael Livermore, instead of saying consider addressing the enforceability of their rules on rules within the rules, if we just said agencies should consider addressing the degree to which they will consider themselves bound, or or the circumstances in which they intend to adhere, something like that, rather than speaking to enforceability.
Reactions on that?
I agree. Yeah, I think the word enforceability connotes judicial enforceability, and it's confusing.
Yeah, I might just change the circumstances in which they intend to have the flexibility to depart or something like that, as opposed to adhere. With the idea being that they would generally adhere.
But I guess that leads to the question of if they're building in this flexibility to depart, then to quote unquote depart, what does that even mean? I mean, how do you depart? How is it a departure if you're just taking advantage of some alternative process?
Is 7 intended to, it's not clear to me. I don't think 7 is clear on its face. Is 7 intended to refer to the bindingness, if you will, internally? Is that what the point of 7 is?
That was the original intention. And it was sort of drawing on recommendations from prior ACUS work or guidance.
I mean, I think it's perfectly fine if it says that, but I don't think, Reeve, I don't know what your thought is on that. I don't think it's clear that it says that. Yeah, I mean, it's implied maybe if you juxtapose 7 and 8, but I don't think on its face 7 is so clear on that point.
I agree, as presently drafted, yes. I agree that it's not clear.
Some of the original language was clear on that point, but Peter? I think we've lost Peter. We can't hear you. I'm sorry.
So agencies should consider the circumstances in which they intend to have the flexibility to depart from their rules on rules, period. If they desire the flexibility to take a different approach, they should consider drafting the rule in such a way that permits officials at a higher level of the agency hierarchy to authorize other officials within the agency to take action that varies from the rule on rulemakings. That was what I thought I had suggested.
Yeah. I think some of it just got lost in the transfer.
Yeah.
Just to go back to Todd's point, which I think was an important one, if the rule is drafted with such a flexibility, I don't think the agency is departing from the rule. They're just using, whatever safety valve that's already in the rule. So I guess that language is a little bit confusing to me.
Right, that depart from the procedures described in the, like that, or specific procedures described in the rule, something like that.
Ordinary procedures.
Yeah, I think the word departs is not there, but the word varies is here, which I think is the same thing. What do we mean by varies? Like, what does that mean? Varies from what?
The default rule is how I understood it.
Mm-hmm.
Maybe like
Default
procedures.
process.
Yeah.
Default procedure process.
Can we say use alternative procedures?
Another alternative, sorry, Connor. Another alternative might be to simply say agencies should consider clarifying whether they consider the rule on rule to be waivable, and if so, by whom. I think that might get to the concept, at least as I understand it.
Yeah, no, that's excellent.
That seems fine to me.
Say that again.
Consider if the extent to which the rule on rule is waivable, and if so, by whom. Is that the general idea?
Yes.
I think that's a good suggestion, but other reactions?
It seems to me that we're talking about whether the procedures required by the rules on rulemaking are waivable, as opposed to whether the rule itself is waivable.
Yes, right.
So,
Not a minute.
so paragraph 7 now, as it reads, would just be one sentence. Agencies should consider the extent to which the procedures required by the rule on rulemaking is waivable, and if so, by whom. Is that the proposal?
I think one. I wonder if you wouldn't still want to say they might consider drafting the rule in such a way that permits officials at a higher level of the agency hierarchy to permit other officials to use alternative procedures. Might rather than should.
Could we also consider listing that as an example, as opposed to suggesting that's kind of the only way? Like, for example, they might consider.
For example, sure.
And how about saying high-level officials?
This is Steph. Minor point.
High-level agency officials.
Yeah.
I think it should be procedures are waivable.
We'll clean this up as well. It's hard to draft on the fly. Do we have an agreement in concept on this language with the caveat that we just clean it up a little bit? Any opposition to this framework? Okay, and then I'm including number 8.
Reeve, can I just jump in here? Connor, can I just jump in here? Reeve, do you think that I guess this sentence, it's still troubling me, paragraph 7. I understand in context, it's clear enough that we're talking about internal bindingness, if you will. I still don't see the first sentence of paragraph 7 being sufficiently explicit on that point. What do you think, Reeve? I'll defer to others. I'm not trying to put my thumb on the scale here. I'm just asking whether this is sufficiently clear.
No objection
Yeah.
to adding internally before waivable.
Yeah, I think that's probably better.
I agree. Yeah. I think this works. I mean, I think it's still a little implicit, but I mean, I think basically it gets at internal bindingness. I think it works.
Any other broad conceptual thoughts on 7 and 8, not drafting?
This is Steph on 8. I'm wondering if, agency procedural rulemakings who lacked such a waiver might ever give rise to judicial review or litigation, even in the absence of issuance of a rule. And I'm thinking about related to petitions for rulemaking or, other, where a rule was not actually issued, but, a litigant still has concerns that the rule on rulemaking wasn't followed. So I'm just wondering if we need to adjust that language to be less specific. I think the point is, in court on judicial review, and then we don't necessarily have to opine on whether or not it's related to if the rule has been issued.
So, okay, so what's the specific, you delete what Todd's highlighting, the idea?
Yeah.
Reactions to deleting the highlighted language.
I think it's a good change. The highlighted language was there only to encapsulate the point that Don Elliott made at the last meeting, but I think that this is good. I think it's better, as Steph suggests, to delete it, and I think Don, if I may speak with him, for him, probably would be fine with that change.
Any opposition? Any other comments on 7 and 8? Okay, hearing none, I will move to vote on the recommendation as drafted. Again, we will send it around after doing committee on staff cleanup. All committee members in favor of the recommendation, please raise your hand and we'll look at the cameras. All opposed, please raise your hand. Opposed? Okay, so thank you very much. Appreciate all the hard work over the 3 meetings. We'll send it around. I was going to open up for yes, Matt or Todd or Reed. Or other remarks.
I don't have any remarks. I have a process question. I just want to clarify so we don't get into an ambiguous situation here. And Reed, please jump in if I'm misstating this. My understanding is that the committee has voted on this recommendation as written, subject to any review on the committee on style, but there will not be a further vote on the recommendation as a whole, with the exception of the appendix. Do I have that correct, Reeve, or did I miss the earlier discussion?
That's my understanding as well, and I guess it would be useful to me as well to sort of clarify what the procedure will be with respect to the appendix. Are we going to send it around with that appendix updated? And then if anybody has an objection to that, then they'll raise it, or are we actually taking a separate vote, email vote after the appendix has been modified? I was a little unclear on that, whether we're basically going to rewrite it by using what we had at the last committee meeting, adding anything from this committee meeting, from the various parentheticals that we had, and then just circulate it, and that would be the end of it, or would there be a separate email vote with respect to at least the appendix itself?
My understanding, Reeve, from the discussion, and again, I'm perfectly fallible here. My understanding is that the committee was going to vote by email on the contents of the appendix. The recommendation is otherwise done subject to any stylistic changes by the committee on style. That is my understanding of where it stands. I'm not telling you where it should stand. I'm just saying that's my understanding, and we should be very clear as to where we stand here.
Sorry for not being clear, Matt. My understanding from the earlier discussion was that the recommendation was locked in principle, committee on style, and then the appendix, we were going to add everything from the parentheticals and the current draft as well as the last list. And then we would not be voting again on the appendix. But
so there would, no, that's fine. I didn't want to accuse you of being unclear. I'm maybe the one who's unclear. So what you're saying, Connor, is that the committee will not vote on the committee will not vote on the contents of the appendix. Is that correct? This is done now.
Yeah, well, we had voted basically today on it by virtue of having the list from the last meeting and having the parentheticals, and we were happy with that. And if somebody had some, violent objection or comment, they can send it in, but we've agreed in principle on the list that we had from last meeting and today.
Well, so agreement on principle is not, I know I may be quibbling here, but I just don't want any confusion here, because I sort of know how these things sometimes go. There's not going to be any further voting on this recommendation. That any further changes to this, now committee members can offer stylistic changes, but the disposition of those suggestions are up to the committee on style. There are not going to be any further votes on this recommendation, either by in person or by email. Is that correct?
All right, well, let's take another vote then. That's my understanding. If everybody's fine with things as Matt just said, raise your hand. If anybody is opposed, raise your hand. Okay, so we'll, as you said, Matt, we'll take stylistic edits.
Are you going to send it around to everybody at this meeting or every ACUS member, or so we can at least read it one more time and submit any input to the committee on style?
Yes. It'll be submitted to the committee, not the full ACUS membership.
Peter, my understanding is that's the standard practice.
My suggestion.
Peter, what is your concern? Peter, why don't you have your say here?
My suggestion was going to be that the appendix gets circulated on a without objection basis, anticipating that there will be no objection to it, and then you'll have satisfied your parliamentary sense.
Are you cool with that, Connor?
That's fine. That's fine with me if that's fine with everybody else.
We also decided to organize the various examples by the bucket list that we created in the recommendation.
Yes, as amended today.
Yes.
Yep. That's fine, and we'll circulate, Todd will circulate the appendix on an objection basis.
Can I ask, I think what Jeff was asking was, you're going to circulate it to the committee, but would you circulate it also to those of us who aren't on the committee, but who have been involved in it?
Yes, the answer is yes, and I misspoke in that regard. The only thing we're not going to do is send it to the whole membership.
Okay, I think that's a good compromise. Thank you, Peter.
Give us a turnaround deadline so we can meet that.
A short one.
Yeah.
Okay. Any further closing comments?
Congratulations.
Thank you very much, everybody. Thank you, Peter, for the suggestion.
Thank you, Connor. Thank you.
And thank you, Todd. Thank you, Todd.
Thank you.
Yeah, I concur. This was remarkable read.